Yes, Your Honor.
All right, thank you. Of course, you're here with your worthy attorney, Ms. Jessica Gonzalez. I'm Judge John Longoria. I'm going to conduct this hearing at this time. So, Ms. Gonzalez, are you going to present testimony?
Yes, Your Honor.
All right, I suspect that's Mr. Sanchez. Mr. Sanchez, please raise your right hand.
Yes, Your Honor.
Mr. Sanchez, do you solemnly swear that in this proceeding, the answers and information you may submit or responses you may submit in information or documents, if any, will be the truth, the whole truth, and nothing but the truth, so help you God?
Do, Your Honor.
All right, thank you. You may put your hand down. Mr. Sanchez, just so you know, at any time, at all times in these proceedings, you have several rights. One of them is the right to remain silent. This hearing is going to be limited to the issue of speedy trial or alleged violations. You understand that?
I do.
All right. In addition, you have the right to have any kind of hearing in public in open court. You agree that you agree to have this hearing now by video conferencing?
Yes, I do, Your Honor.
All right, thank you. Ms. Gonzalez, you may proceed. It's your motion.
Yes, thank you, sir. And you just reminded me the first thing I needed to say was when I'm calling this witness, I am calling my client for the limited purposes of this speedy trial motion.
That's understood and noted.
Okay, thank you. All right. So, Mr. Sanchez, can you please state your full name for the record?
Christopher Sanchez.
Thank you. And are you the person that is charged under the information for the offense of driving while intoxicated?
Yes.
All right. And do you remember off the top of your head what date you were arrested?
Not the top of the day, but I just remember the event that happened that day.
Right. But can you try to guess what day it was? Not the exact date, but maybe what year and month?
September, 2018. It's like when Canelo and Triple G fought. It was like September 16, I think. Or
Okay.
7, 15, 16.
Okay.
I'm sorry. Can he repeat that? He cut out for a second there.
Right, I didn't get that either.
Yeah, it was about September 15, 16, when there was a huge boxing event that day.
Okay. And so are you talking about 2018?
Yes, 2018.
Okay. Now, when you were arrested, were you given any bond conditions by the magistrate or this judge that you had to follow while you've been on awaiting trial?
Yes, interlock. Within the first week, I had to get it within 5 days.
Okay. And did you actually get ignition interlock on your vehicle?
I did.
All right. Can you repeat that?
Yes, I did.
Okay. And so that would be approximately either the last week of September 2018 or October 2018, correct?
Correct. Yes, correct.
And have you maintained interlock on your vehicle since then?
Yes, just a small period of time that I had the ankle monitor for 3 months, but other than that, I've had it on ever since.
Okay. And are you bearing the cost of that ignition interlock?
Yes.
Okay. For the record, approximately how much is that per month?
It's 100. It's about 90 a month.
Okay. Now, at any point in time, was there an additional condition of anabuse added to your bond conditions?
Yes, just recently, the last month.
All right. So. And how much does anabuse cost you a month?
$9 a month. I have to take it 3 times a day. 3 times a week. So that's 36 times 4, about 24. It's 12. It's almost 130, 100, around 130 ballpark. 130 a month.
Okay, and that will be in addition to the cost of the interlock that's currently on your vehicle, correct?
Correct, and added on to that, yes.
Okay. Now, let's go ahead and talk about your financial status. Were you considered by the judicial system to be an indigent person?
Yes.
Okay. Did you apply for that when you were booked and going through the booking process? Did you request an attorney?
Yes, I did.
When you requested an attorney, did you have any say as to who was appointed by the court system?
No, I wasn't.
Okay. When was the first time you had contact with your attorney?
Probably within the first week of me having those papers. In that week, I called him and we set a meeting and
Okay.
I spoke to him in person, actually. I
Okay.
told him,
Wait, I'm sorry. Go ahead.
oh yeah, I spoke to him in person, told him what happened, and I told him everything. And he said he pretty much had it. He's like, oh, okay, I got this. It's okay. So then day came, he never showed the first day. First
Okay.
day of
Let
court.
me Okay, let me interrupt you for a second. When you said that you told him everything, are you talking about your defense of necessity?
I just told him what happened that day, what the reason I got behind the wheel, and why I was fleeing.
Okay, we'll go ahead and we'll circle back to that once we finish this part. But so you met with the attorney and you did explain to him that you felt that you had a reason for why you may have committed this alleged offense, correct?
Correct.
And did you appear in court on that first court setting?
Yes, I did.
Okay. And have you had multiple court settings since that first court appearance?
Yes, I have.
And have you gone to court at those court appearances?
Every single one of them.
And approximately how many court appearances has that been since September 2018?
Oh, maybe about 16, close to 18 times I've gone.
Okay. And at one point in time, did you consider entering into a plea agreement with the state of Texas?
Um, After Trevor wasn't really doing much, I just told him yes, I did, and then he said he had he objected at the very last moment, and he told me that he's got this, and we have a real fighting chance. I was like, oh, even better. I actually lost hope in him because he wasn't really doing much.
Now,
Uh,
for the record, did you ever approach the court and request a different attorney?
I didn't know I can do that.
I'm
I
sorry,
thought I
can
was
you
just stuck.
repeat that?
I didn't know I can do that. I thought I was just stuck with him.
Okay. Now, after you withdrew your plea bargain, what happened?
Sorry. Well, he just spoke to me on the side, said that there is a fighting chance that he's gonna. We have a great standing. We have a great opportunity of winning. I was like, okay. But after that, he really didn't say much. He just said he had it all under control. That I didn't have to worry about much.
Do you remember which court appearance that this conversation happened on?
It was like the beginning of the year. No, yes, it was the beginning of the year because um, it was January. It was January when I spoke to him. Because
Okay.
then the following month was when I was like really like I was just I was curious what was really gonna happen, but he never
Okay.
showed up.
So you did at one point get it set on the jury trial docket, but you're saying that he did not show up for that appearance?
No, he didn't.
And at this point in time, is that when I was appointed to this case?
Correct.
And do you remember speaking to me at that first setting when I was appointed?
Yes, we stayed about like at the bit. We were the last ones to leave. That's for sure.
Okay. And did we talk about this defense of necessity?
Yes.
And at that point, did I set this case for trial immediately?
Correct.
Okay. Now let's go ahead and circle back to this necessity. Talking about specifically why you got into your vehicle on that day. Can you please explain to the court why it is that you got behind the wheel?
Well, I got attacked by some guys. Honestly, it was because of the shirt I was wearing. I know it was because they were. I was wearing a Triple G shirt that day. It was a Canelo and Triple G fight that day, and I was walking along with my friend, and I got swooped from my feet and hit in the head, and I got dropped on the floor, and I just kept getting beat up, and the security guard came, and like everyone just like, I just ran. I just kept running. I didn't want to look back. I just ran.
All
And I
right, let
just,
me pause you right there. If you remember, approximately how many people, if you know, attacked you?
at the moment, I just felt like, hits from my. I personally didn't know until they told me how many they were. When I spoke to the security guard like months later, he told me there was about six of them, and
All right, and were you physically assaulted?
yes, I was.
Did you receive physical injuries from this assault?
I did. I got a couple scars and pretty bad knee.
All right, Your Honor, at this point in time, I'd like the permission of the court to go into a screen share for me so I can present defense exhibits 1 through 9.
Go ahead.
Okay,
You have my permission.
thank you. I just got to figure it out, Your Honor. I don't know if Michelle needs to leave the screen share because that's okay.
Sure.
Thank you. Thank you.
Mhm.
All right. Alrighty. All right, to the court. Can everybody see my screen?
I can see a multitude. Let's see, seven, appear to be 7 exhibits or at least
Okay.
photos.
Okay, I'm gonna start opening them up one by one, Christopher. I'm gonna show you each one of them one at a time, and then I'm gonna ask you some questions after I show the exhibits. So I just want you to take a look at them and be ready to answer my questions afterwards.
Okay.
Somebody know.
Your Honor, this hearing is limited specifically to the speedy trial issue, is it not?
That's my understanding, Mr. Yanta.
Okay.
All right, Christopher, after looking at defense exhibits 1 through 9, do you recognize these pictures?
Yes, I took them about like within a week of the incident happening.
All right, so is this how you appeared? Are these injuries that we can see in these photographs from the assault that you just described to the court?
Yes, those are. I probably look worse that day actually. I was more swollen, much more swollen.
Okay, so is it fair to say that these pictures, defense exhibits 1 through 9, are these a fair and accurate representation of the way that you looked after the arrest and then the assault that you sustained from other individuals?
Yes.
All right. At this time, Your Honor, I'd like to admit defense exhibits 1 through 9 into evidence.
Mr. Yanta?
Your Honor, I'm not sure what this has to do with the speedy trial issue. It seems like we're taking this on the merits at this point.
May I reply, Your Honor?
Of course, I
After-
suggest that you better.
Thank you. After these exhibits are entered, I'm then going to go and talk about the witness that my client is describing as the person that was able to get him away from these individuals, and that is why he was fleeing, hence goes towards the necessity defense. And that in turn, he will explain what he's done to contact this witness and how this witness is now lost and why it is necessary and vital to his case. So it goes directly to his speedy trial violation claim.
Mr. Yanta, do you want to oppose that, or do you want to stipulate to the facts?
Well, the state maintains its objection, Your Honor. I'm not sure what these. Still, I don't think that the defense counsel has enunciated the correlation between this and the speedy trial issue of the missing witness, as the motion states. The extent of the injuries, which I assume is what is being displayed here, because I can't make out the photos. They're icons right now, little thumbnails, but still the same objection, Your Honor, as to its bearing on the speedy trial issue in defense's 1.5 page motion.
Well, the bearing of this, I understand, for which is being offered is damage or injury that's been received. And I don't mean a pun by it. I don't mean to use it as a pun. The injury to the defense's case as an element of the violation of speedy trial apparently is being offered, that there is a vital witness that is no longer available because of the delay.
Correct, Your Honor.
So what say you to that, Mr. Yanta?
Same objection, Your Honor.
All right, under the circumstances, it's a little bit narrow, but I'm going to overrule it. I understand the purpose of it. I don't necessarily need to see all the photos and stuff, but since they're available, that's fine. We'll make it part of the record.
Thank you, Your Honor. Now, Christopher, you were describing that there was a witness that helped you with it after or during this assault happened. Can you please tell me about who this witness is from what you understand?
So like I said, at the moment, I didn't know all this was happening. I found this out when I saw the guy. He explained to me that he saw all these guys just kicking me and hitting me, and he's a security guard from La Botonica. He was a security guard at La Botonica. He ran from where he was at to come and, break up what was happening.
I'm sorry, Your Honor, I couldn't make out his answer to that question. There was cutting out. If the witness.
Would you repeat that, Mr. Sanchez?
Yes. So the witness, the guy who broke everything up, was a security guard that worked across the street at La Botonica. And once he saw like 6 or 7 guys just kicking me and just beating me up, like just going at it, he ran and he said he threw pepper spray, and then that's when I got away, and then that's pretty much what happened.
Okay. And let's go a little bit more into detail about this witness. You said he was a security guard in this area?
Yes, he was there for a good while. I didn't go back until probably like the end of the year, and I saw him, and that's when he had told me what had happened, what had really happened. Because I just remember like getting hit and knocked down, and then and I just ran away. Okay. He told me that he saw that there's people just kicking on me, and that's when he came in and stopped it all. And then.
Okay. Now, is this information that you told to your court-appointed attorney?
Yes.
Okay. And is this information that you actually also told to the police officer who stopped you that evening?
At the moment, I didn't know. I didn't know.
Okay, let me ask you this. Have you reviewed the police report that was generated with your arrest?
No. Yes, I'm sorry. Yes, I have.
We went over it yesterday, correct?
Correct, we did.
And it is documented in the police report that you provided information about you being assaulted, correct?
Correct, yes, correct.
And even if the court-appointed attorney had not spoken with you about this information, he would have also seen it by reading the police report, correct?
Of course, yes. I understand your question now. Yes, correct.
All right. Now, let me check my notes real quick. Have you made attempts to go back and find this witness since you saw him in December of 2018?
I have, but he had recently, like within that end of the year, he was gone. He no longer worked there. I spoke to several of the other employees, other security. They remember him. They just never knew his name, and I never got a straight name or a phone number or like a Facebook or something I can contact him. But I've been trying. I really have, because
Okay.
he was there, and he's vital to this case.
And let me ask you this. When you say the end of the year, are you talking about the end of the year of 2018 or the end of the year 2019?
18, end of
Okay.
18.
Now, is there any other witnesses that you know of that actually saw this assault firsthand?
Other than the person that was next to me, but he ran away too. Like he ran after he didn't do nothing to help me. So he just like, I had a friend with me, but he ran like after I had a friend with me, but he ran when he saw that happening, when the security guard came and whatever. But I had a friend that was with me, but I don't know how much he saw, but he just ran when they all started attacking me.
And so was the friend around to see the pepper spray and the later part of it?
Yes, from a distance, yeah, because he ran. I mean, but yes, he did get to see it.
Okay. And when was the last time you contacted that friend about this?
Not in a good while. I probably haven't spoken to him like since the beginning of the year, actually.
Okay.
About this incident, maybe longer than that.
But this is a friend of yours, correct?
Correct. Yes.
Okay. But the security guard that we're talking about that you're saying is vital to the case, that's somebody that you do not know, correct?
Yeah, that's someone I don't know. Yeah, I didn't know him.
So no prior relationship, no relationship afterwards. He's an unbiased witness.
Correct.
Thank you, Your Honor. At this time, I think I've reviewed my notes and I think that's all I have for right now. So I'll pass the witness for cross-examination.
All right. Mr. Yanta, anything?
Yes, sir. May I proceed?
Certainly.
Good morning.
Good morning.
You understand why we're having to do the video conferencing? What's going on?
Correct. Yes.
Okay. Why is that? Why do you think that is?
The COVID
Right.
separation.
Right.
Say one more time.
That's the COVID-19 epidemic that's going on.
Epidemic. Yes. Coronavirus. Yes.
Right.
This thing.
Does the COVID-19 pandemic, does it scare you? Does it kind of make you nervous?
Yes, I'm pretty sure it makes everybody nervous, especially for the family members, for the ones who are really at risk.
Right. Make you anxious at all going out?
Yeah, I don't even go anywhere. Yeah.
You had mentioned just from the top that this happened in September of 2018, this DWI second charge. You said it was because of a boxing event, a big boxing event that was going on?
Well, I'm thinking the reason they hit me was because I was wearing a certain type of shirt, because I had a Triple G shirt on, and I just remember hearing them saying, like when they're hitting me, like "fuck Triple G." Like I know that's why they're hitting me, because I had my shirt on.
And what is Triple G? I'm not familiar with that.
I'm sorry. There's just boxers. They're just boxers.
Okay.
Triple G is Gennady Golovkin.
There you go. I didn't know his full. Yeah, it's a big.
Gennady Gennadiyevich Golovkin. That's why he's Triple G. Sorry to interrupt.
No.
Let the record reflect that my esteemed colleague Andrew Edelman, also an ADA in this court, that he just piped up about Triple G.
We don't know since he wasn't under oath. Go ahead, Mr. Yanta.
Thank you. So you'd mentioned it happened in September 2018. And there was reference to the charging instrument that your attorney asked you about. Are you familiar with your charge, what you've been charged with?
Yes.
Okay, and what is that?
Driving on, well, it's evading a stop sign and it's speeding. That's what the report said.
Okay, but why are you here in this court today?
Because I feel that I feel that over what happened, I didn't. How do I say this? Because the reason I got behind the wheel, it was because I was fleeing for my safety. I was trying to get to safety. All I thought was in my head was safety.
Right, but
And
I'm
say
sorry,
again.
sorry to interrupt. There's a bit of a delay, a 1 or 2 second delay, so I apologize to the court reporter if our questions are interrupting his answers. So for the benefit of the court reporter, let's try to minimize the interruption, just for the benefit of all involved as well. But back to my question, I'm trying to let me make it easier for you. What have you been charged with in this court for this cause number?
DUI.
Okay, that's not correct, is it?
Driving intoxicated. I don't know.
Driving.
DUI? Is it a DWI? I'm sorry.
Right. Yeah. That's right. Your information, your charging instrument says DWI second. So not DUI or DWI. I just wanted to make it clear.
Okay. Yeah. I mean,
Hold on. Objection, Your Honor. I don't see how that's relevant as to his prior criminal history as to whether or not he violated his rights to speedy trial.
Prior criminal history. Oh, may I respond to that, Your Honor?
Please do.
It's on the charging instrument. It's at all times relevant.
But Your Honor, whether or not he's charged with driving while intoxicated second, or murder, it has no bearing on whether or not his rights were actually violated and whether or not he's actually suffered a prejudice. I think that that is extremely improper of the district attorney's office to try to bring that out, trying to indicate that because he has a criminal history and this is the second time he's being accused of it, trying to lessen or say that or insinuate that my client has less of a right to a speedy trial.
I'm gonna go ahead. Pardon me. I'm gonna go ahead and allow it as being within the broad right to cross-examine. But I think your point is well taken, but I am going to allow it.
Thank you, Your Honor.
Proceed, Mr. Yanta.
Thank you. You had mentioned that there was a friend with you
correct.
when this event happened.
Correct.
What's the friend's name?
Steven Gonzalez with an S.
Steven Gonzalez with an S.
Yes.
Okay. And it was your testimony that you're not sure whether he saw anything or not. Isn't that correct?
Yeah, because well, like I was pretty much alone, so I'm like, for me, well, he told me what he saw. I mean, I don't know where he was standing, but he told me what, because like we spoke afterwards, you know. But at that moment, I didn't know what, I was just on the floor, face down, getting kicked. I don't know where he was. I don't know where anyone was at.
Okay, but it was your testimony that you were not sure what he saw. Isn't that correct?
Well, I'm sorry I said that, but like I said, I spoke to him like that within like me getting out, because he was actually waiting for me at my house because of what happened, and I never made it home. 'Cause I was, you know, I pulled over.
Okay. Now you had testified that you were physically struck by, or were these strangers?
Yeah, I don't even know who they are. Like I stopped going to that place just because I didn't know who these people were.
Okay. And did you ever call the police to report that?
I did the next day, because I guess the arresting officer didn't. arresting officer didn't write that or didn't file a case, but I did the next day. I did call the police the next day to make a report about it.
Okay. And is there a report? Have you seen the report for that?
No, he never got back to me on it.
Okay. And you had gone back, your testimony was that you had gone back in December of, what was it, 2018?
Yes, correct.
Okay. And why did you go back?
Just hanging out with my friends, you know, DD. I was just a DD,
And by,
designated driver,
I'm sorry.
or DD. I don't know, designated driver. I hung out with my friends, you know.
Okay, so in December 2018, you went as the designated driver for
Yeah,
your,
we're just hanging out with my friends, you know. Yeah, just going out. I
okay.
mean, I was under the monitor. I pretty much took my truck everywhere.
Now, do you recall the security guard's name?
No, I barely knew the guy, and he recognized me when when I was walking. He recognized me and approached me.
Oh, okay. In December 2018, did you ask his name?
I did, but like it slipped my mind after. I mean, it's a couple years now. But yeah, no, I didn't. I can't remember his name.
Now, you said in December 2018 you were driving your truck, but you have more than one truck, don't you?
I used one for work. Yes, correct. A working truck, but it broke down.
And what truck were you driving in December 2018?
A Chevy 2005.
Okay. And on the 2005 Chevy that you were driving in December of 2018, did you have an ignition interlock equipped on that 2005 Chevy pickup?
And Your Honor,
No,
before my client answers, I'm going to object to this line of questioning. Again, I don't see how this is relevant to the speedy trial violations and arguments that we're presenting to the court this morning.
Your Honor, may I respond?
Go ahead, Mr. Yanta, but well, never mind. I'm going to sustain that. It's a little too far afield.
Too far afield, Your Honor, if I may respond.
Go ahead.
I'd like the court to take judicial notice of the record because this defendant has gotten 5 violations that go directly to the delays in this court's proceedings, including one as recently as April. And it was his testimony that he was driving a vehicle, a truck, in December 2018 that was not equipped with the ignition interlock, Your Honor. If the court takes judicial notice of the record, that is reflected in the record. In fact, the subject of the first violation was for this reason. Operation of his...
Mr. Yanta, what's the purpose of the material you're offering in reference to the speedy trial?
Is that the docket sheet reflects 5 violations for which this defendant has had to appear before this court, including one in which the defendant actually asked his attorney last year, well, I assume he asked his attorney last year to amend the conditions of one of his bonds so that he can allow travel outside the county.
And Your Honor, if I may respond, while I do object to it, it also points to the prejudice that my client has actually suffered while he's been awaiting the delay of this trial for over 18 months. So I still think it is irrelevant to this hearing that he's had the violations, other than the fact that he has been under bond conditions for the past 18 months.
You guys are starting to lose me on this issue. How is it? What is the reason for all these delays?
The delays on the delays for the trial, or the subject of the speedy trial hearing, or the bond conditions?
Well, the bond conditions go with just the pendency between the arrest and the trial itself. My question is, where does all this fit with violation of speedy trial? What are you alleging as far as, I don't have any doubt of the prejudice because of the length of time, if in fact it's unjustified. So what are you telling me about the lack of justification?
Do you
Mr.
mean
Yanta, where are we there?
Yes, Your Honor. I could go ahead and go through the reasons that we're just now having this speedy trial hearing. This case wasn't set for jury trial until January of this year, and at that date, I don't believe defense counsel had shown up, and that's the reason for Ms. Gonzalez's appointment in late January. And prior to that, Your Honor, this case had been reset by the defense attorney that the defendant had at the time several times, none of which count against the state, Your Honor, including March. And if with the court's permission, I'd like to go through the criminal docket in this case, starting with.
Sorry, Mr. Yanta. I have no objections to that. I actually agree with that.
All right, so when was it first set for court?
It was set, there was a setting on October 8th, 2018, but the notes are that the defense attorney had family medical emergency, so it was reset for PTC. And the next was November 5th, and that was no file was created yet because we were, I believe, still waiting on test results for the defendant's blood specimen in this case. And then the next setting was February 5th, in which the court authorized the defendant to switch ignition interlock to an alternate vehicle, Chevy Avalanche. Defense attorney to bring written orders specifically identifying the vehicle, and that was reset by the court 30 days.
Was there a specific trial setting or request by anybody?
No, sir, not until January 21st, the first trial setting, at which point.
21st of 19 or 20?
2020, Your Honor. So, but if may I proceed, Your Honor?
Yes, sir.
Thank you. Then on March 21st of 2019, this case was reset because the defense attorney was on vacation.
All right.
And then on June 6, 2019, Your Honor, the attorney had a setting in Comal County that day, and so it was reset for a pretrial conference, another one. Then on July 11th, the next setting, there was an agreed reset for a plea, and that was reset to August 15th, in which case the defense counsel again was detained at district courts out of county, and so he reset it again for a plea to September 27th. And in between that time, there was a violation report, and I'm just reading from the docket notes here. There was another violation report on August 28th, 2019, and then finally on September 16th of 2019, the defendant was placed on scram and ignition interlock was removed as a condition once the scram was installed. And then fast forward,
what was the date of that?
That was September 16th of 2019, Your Honor.
All right.
And then the warrant was recalled after the third violation report, Your Honor, in September 27th, 2019. This court gave the defendant 3 days to obtain scram, then remove ignition interlock, 90 days of zero violation, defendant to install ignition interlock, and then have scram removed. And this case wasn't even set for the trial docket until January 20, I believe it's the 21st. Defense counsel Gonzalez?
I believe so, Mr. Virgil.
Okay.
Or Mr. Yanta.
I like Mr. Virgil. I'll go with that one. So, and even at the first trial setting, Your Honor, I don't believe there were any announcements made, ready or not ready, but the defense counsel, I believe, didn't even appear. And again, that's the reason that Ms. Gonzalez, Ms. Jessica, was appointed as the defendant's new counsel. Now, if I believe Edelman, can you pipe up here? Because I think were you present at that hearing, or the notes? It said that the defense counsel didn't appear on the 21st of January at the first trial setting. Is that right?
That's correct.
Okay. So, Your Honor, if you look at the defense's
Yanta, I apologize. The notes were not merely that the defense counsel did not appear. The notes were that the defense counsel did not appear and did not notify the court.
Okay. Thank you. And Your Honor, if I may draw your attention to the defense's motion here for speedy trial filed in late February. She announced that the state was not ready to go to trial, but that's not represented by the record here because there was no not ready announcement from the state, I believe.
And Your Honor, I'm going to object to that one point. Is I believe that my motion, if I'm looking at it correct, is that the trial has been set for May 11th. I don't have anything about a state. I said if the state were to announce not ready, then there'd be a violation from the state part of it. But I have other arguments for why there's still the violations. But I don't think I put in there that the state was not ready at any of these settings, other than the fact of they didn't have the file ready.
That's fine. Okay.
Your Honor, may I respond?
It's not necessary at this point, Mr. Yanta. I don't find it convincing. Now, Ms. Gonzalez, do you have anything else
As far as arguments, Your Honor?
on your motion?
Yes, Your Honor. I know and I understand that this is a very new and novel argument. And by making this argument to this court, who all the staff members, I completely and highly respect in how they do their job. However, I believe that my client's constitutional rights to a Sixth Amendment speedy trial have been violated by the court system as a whole. While I agree with Mr. Yanta's recitation of the docket notes, there is a clear problem with the attorney that was appointed to represent my client before I came onto the case. As my client outlined in his testimony, he was considered from the immediate arrest that he was an indigent person. As an indigent person, our system appointed him a court-appointed attorney as provided by our Constitution. He is given representation if he cannot afford representation. As we all know, as all of us practicing in our system for many, many years, a person, once they've been declared indigent, does not have a choice in their attorney. And not only do they not have a choice in their attorney, I have, in my practice of doing this as a defense attorney for over 8 years now, I have only been removed from a case or seen a person removed from a case after many problems. It does not happen. And the case law is very clear that even though the Constitution guarantees an indigent person and a court-appointed attorney, the case law specifically says they do not get their choice in a court-appointed attorney. And that is where our system failed my client at this point in time. I'm not blaming the state, other than Mr. Yanta's recitation of this problem, or this part where the state has a reset on there because of the fact that they had not filed the charges against my client. He was on bond conditions and they were still awaiting evidence and still doing an investigation. And so there is a delay right there with the district attorney's office. However, the system—
How long was there no proceeding because of the no file? When did they first have it filed?
I apologize, Your Honor. I do not have the specific docket sheet from the actual court file. All I have is the case events of what I'm able to pull up on online. And I don't believe that there's a specific notation as far as the coding. So I don't know what setting it was, which setting it was that there was a
What-
reset because the
What
state.
about the complaint? That would tell us when there was a
Judge,
file
Your
created.
Honor,
Please,
I could fill the court in on this. On the docket sheet, November 8th, 2018, that was when, and that's what I recited, 90 days, no file yet created. That had been set into February 5th, 2019. The complaint was filed on November 15th of 2018. And so 10 days after that, the state had filed this case. Actually, yes, that's correct. So the only at which this case was set for trial, and I'd like to also turn the court's attention to the testimony that the defendant.
Patty, we need to have you muted. Thank you. May I continue with my argument, Your Honor?
yes, ma'am.
Yeah, Your Honor, I wasn't done. I was interrupted by defense
Go
counsel.
ahead,
Oh,
Mr.
I'm sorry.
Yanta. Go ahead, Mr. Yanta.
Thank you. So the only time that this case was set for trial, the first trial setting was January 21st of this year. None of the reasons, with the exception of the November 5th setting, in which this was reset 90 days because no file had been created yet because we were waiting test results on the defendant's blood. None of these points
That
count.
was November 18th or 19th?
November 5th, 2018 was the setting. This case got filed on November, excuse me, he was charged November 15th, 2018, Your Honor.
Okay. All right.
And through all of these reasons for the resets, none of these count against the
Yeah,
state.
I understood that, Mr. Yanta.
Thank you.
Ms. Gonzalez, go ahead and finish your position or your statement.
Yes. Yeah, thank you, Your Honor. So where I was is saying that the system should have put this case on the trial docket way sooner than February 2020. The only reason I was brought in on the case was because Ms. Garcia and the court did notice that the attorney that was appointed prior to my representation had not done what they were supposed to do in putting this case on the trial docket. Even though, as my client testified, and as we talked about what was in the police report, it is completely apparent that there is a need with a necessity defense for this case to have been placed on the trial docket. So thank goodness Patty noticed this. However, we're still looking at I believe about a 15-month delay. At that time that I was placed on this case, I did set it immediately for trial. I also notified the court verbally that I intended to file a speedy trial demand with the sole intention of, if the fact that the district attorneys did announce not ready at our first trial setting, that be considered a violation, even though that would be technically considered their first not ready on the trial docket. However, in investigating this case further with my client, that is where I learned of this witness. And I actually spoke to my client, asked him to see if he can continue finding this witness. He was not able to find anything about this witness. And that is where the true and actual violation of prejudicial harm comes to my client. Whether or not there's actually another witness that he referred to in this hearing as the friend of his that he's spoken to, he's unsure about how much that person actually saw. But I know just from my experience as a prosecutor and as a defense attorney, the state of Texas, rightfully so, is going to jump all over this witness and say that this is a biased witness. This witness has known my client. He has a bias to be able to help his friend and come in and testify to whatever his friend needs.
You're starting to stray a little bit now from the speedy trial issue. I understand the point that you've made that there is a possible loss of witness, which would be part of a speedy trial issue. We still got to get back to the essentials, and quite frankly, the fact that an attorney, a defense attorney, may have been lacking in his or her diligence is not going to be imputed, not by this court, is not going to be imputed to the state. And do you have anything further?
And I agree with the judge. It does not need to be imputed on the state. The state is not responsible for making sure that a valid defense attorney is doing their job. What I'm saying is the criminal justice system as a whole and the court who is in charge of appointing attorneys had the responsibility to make sure that this was taken care of properly. We're now talking about somebody who's been on bond conditions and awaiting trial or awaiting the disposition of his case for 18 months. He's bared the burden of the trial settings and the bond conditions, and he has lost an unbiased witness, which is what my point is the fact that this witness is unbiased as opposed to any other potential biased witnesses.
I don't disagree with your position on that particular issue about
Yeah.
possible loss. Uh, if the worthy defense attorney applies for the assistance of an investigator to track down that individual, which I think will not be that terribly difficult, particularly since security guards are licensed, it may well be that you can produce that person. Now, I understand the essence of what you're arguing, that it is the system that failed your defendant. Very possibly, you are aware that you were appointed because the system recognized the somebody's lack of diligence.
Absolutely. And my client does truly appreciate the fact that the system did understand this and recognize it and did appoint me to this case. So, so the last part of it is something that we touched on in the hearing on an unrelated case on Monday, which is the fact that where we stand right now and with the recent update that was provided by Judge Nelson Wolf yesterday in the court, the San Antonio's daily briefing of our situation, we are not expected to be resuming jury trials until September of 2020. Now, I understand that the executive order does provide for a limited selection or jury trials in a limited fashion. However, it is my understanding also that the Bexar County system, including the district courts, does not have a system in place as to how we will be able to resume jury trials. And one of the requirements from this executive order is that we will have to have a system in place before we can actually start that system. Furthermore, once we do get this started, when we're talking about my client, if we are looking at doing limited jury pools and starting limited jury trials, my client is going to be at the very bottom. The only people that are going to be below him are going to be the JP courts and the municipal court jury pools,
Right.
jury
Now,
trials.
let me go ahead and interrupt you.
Yes.
I fully appreciate what you are arguing. The problem is I don't accept it because these are unusual and extreme circumstances that we're under. So does that inure to the benefit of the defendant, or does it prejudice the state? And both of them are no. It's not caused by the state, in my opinion, nor is it going to be to the benefit of the defendant, because he just has to face the system under the extreme circumstances. Otherwise, we'd be pushing him to the front of the line for a trial because he's demanding a speedy trial. So, you have anything?
Nothing further. I am asking that the court find the prejudicial harm is already so severe now that it's going to limit his right for the speedy trial. Of course, if the court finds that there's the violation.
Further, I do recognize that this is a.
I'm sorry, sir, you broke up.
Pardon me?
Can you repeat that? There's some other noise.
It might be my clock.
Got it.
Anyway, I'm going to deny your motion. I think it is, as I said, novel. It's important. You are being diligent on behalf of your client, but at this point, the state has not violated. When I say the state, perhaps the system in great generalities has, but we have moved on it, I think, appropriately. And it appears from the record that most of the delays, almost exclusively, were due to the defense, your previous defense counsel. And that's something that might be taken up later on by somebody else, but at this point, the court will deny the motion.
Thank you. And Your Honor, if I can get clarification, I would ask in the alternative, instead of denying the motion flat out, I would ask that the court find that there have been delays and that the defendant be given his immediate trial setting, and that if the state is to try to say at that first trial setting that they are not ready, then we can be able to have a dismissal at that point, that they do not have another opportunity, since this has been going on for 18 months. And I imagine an additional 18 months before we actually see trial. If the state announces not ready at that trial setting, that the case be dismissed at that point in time.
I'm not gonna make that commitment. Good try. Good try, but no, I'm not gonna make that commitment. I will ask Ms. Garcia, my coordinator, to try to expedite trial if and when it's available. Well, I shouldn't say if, it will be, it's a matter of when. So, and again, a lot of this is due to a previous defense counsel and also the circumstances where your own client continues, or at least allegedly continues, to violate his conditions. I strongly suggest that you visit with your client for his benefit and make it clear that this court does not appreciate multiple violations of the conditions that he's supposed to live under. Remind him also that if he's driving one car and has the ignition interlock on another, that kind of thing, I realize he's on scram now, isn't he?
I believe it's the anti-abuse pill, Your Honor.
Pardon me?
The anti-abuse pill, the scram was removed. That was just temporary while they were fixing which car the ignition interlock was going to go in. He is now on ignition interlock that is installed, and he has the anti-abuse pill.
Okay. All right. Just remind him that he's going to dig himself into a rough position if he continues to violate, because I'm not going to tolerate it.
And Your Honor, I would actually be asking that if we are looking at an additional delay, which we all know we are because of our circumstances, is to have some relief on those bond conditions, because it is an incredible prejudicial burden to have them on both devices. And we're looking at now 18 months of some type of alcohol monitoring that's been going on with my client, which even if he is charged with a DWI second and convicted of a DWI second, ignition interlock or these monitoring devices would not be on for this length of time. It is an incredible burden for my client that, given the circumstances we have right now, he is having an incredible difficulty meeting for financial reasons.
Okay.
So I would
Again, your argument is a good one, but he is his own worst enemy. I rarely release people off of monitors if they have continuously been alleged, notice how I say alleged,
I understand.
to be in violation of the conditions. I don't like being oppressive with our monitors and attributes and stuff, but if he shows me a pattern of staying off of alcohol and not doing blood alcohol content breaths, I'm the first one that likes to see people off of those things.
Yes,
But
Your
on
Honor.
the other side of it is, if you've got violations even the last month or 2 months ago, he's not going to be able to come to me and ask me to go easy on him, because I ain't, especially on the DWI second. I said before, and I'll always say, my first duty is the oath of office, Constitution and laws. Second duty, in my opinion, is to protect the community at large. And then the third duty is to do what I can for the defendant. And they're in those order, in that order. All right, so that'll probably be, that'll conclude this hearing at this time. Anything else before I conclude it officially? Ms. Gonzalez.
Yes, Your Honor. To speak to what you just said, I will have that conversation again with my client. But two, yes, I actually do have other motions that were filed during this time that we've been waiting for this hearing. that I would like to bring to the attention to the court to have them heard and signed for the orders so that I may get court orders on them.
All right, which ones? They're on the same defendant?
Yes, Your Honor, they are on the
Okay.
same defendant.
Tell me
Just
what you got.
to give you a little bit of a background, Your Honor, back on March 24th, 2020, the district attorney's office filed 2 motions, one of which being the state's request for disclosure of defense experts. I did not have a problem with that.
Objection, Your Honor. If there weren't motions, I just want it known for the record. They were proper discovery requests.
Correct.
There's a valid difference here. And
Okay,
I just want that on the record. These were not motions, but discovery requests properly filed.
And that is correct, Your Honor. It was state's request, which led me to file the motions that I want to address with the court. So the first one being the request for the notice on a defense expert. The second one, if you can give me a moment, Your Honor, it was for a request of the defense's intention under Texas Rules of Evidence 609F, a request for notice to be given by the defense to the state of evidence that we intend to use as far as convictions of any of the witnesses. This motion, Your Honor, is the one that I found to be incredibly concerning. So based off of that, I filed.
Not a motion, not a motion. This is a discovery request, not requiring the court's intervention prior to the defense having to act. It's not a motion.
Okay, state's request. I filed a motion because I found this request concerning. I filed a motion for discovery of exculpatory and mitigating evidence, typically called a Brady motion, that I'm asking for the court's signature on. Furthermore, I am also filed a motion on, and I filed all these motions on March 27th, a motion for the discovery of the arrest and conviction records of the state's witnesses. As part of the notices that were given by the state did tender on April 9th, the state's witness list, which includes an officer, a nurse, and a toxicology person who did the lab testing for the blood results. My concern is when the state files a request with to the defense asking to know what conviction evidence I intend to use against the witnesses in the case, and the witnesses are only a police officer, a nurse, and a lab technician, I have concerns, and this raises red flags that there may be some issues with his witnesses that I am unaware of. So hence I filed the request that I did file so that I can get that convictions, get that information, and then I will be able to properly respond to their requests. So those are the motions that I'm asking for the court to go ahead and order. So that way the state I can present the state with an order to give me that information. Furthermore, in reviewing the e-discovery on this case, I did receive a memo of disclosure concerning Officer Zimmerman, who was the officer that did the traffic stop. There are very little information that is actually provided by Officer Zimmerman. It's Officer Daniel Zimmerman, badge number 1605. And it looks like there was an internal investigation that was done on inappropriate treatment of a person in custody arising from something that happened on February 5th, 2016. He was suspended because of this. Now, based on the request that I received from the district attorney's office about convictions and information I intend to use against witnesses, the fact that this is a witness on their case and I've received a memo of disclosure, I am asking the court to order that the district attorney's office provide me this record of Officer Zimmerman, the details of it, and the arrest records that I just previously cited to, and any Brady information that may be used in trial. That way, not only can I use it in trial to protect the constitutional rights of my client, but I can also comply with the state's request that they filed in March.
Your Honor, if I might respond.
Please do.
609F discovery request was properly filed and served. That is reciprocal discovery. That one of the few mechanisms that the state has to discover the intent of the defense to use convictions, not only for its own witnesses, but for the defense's witnesses. So we're still not aware of whether there's any witnesses that the defense intends to call. So the purpose of that is not to cover just the state's witnesses, but also those of the defense, to discover the convictions that the other side, that the defense in this case, intends to use at trial. And that was a properly served and filed discovery request. And it's not, that alone wouldn't be enough to trigger, mere suspicions isn't enough to trigger an exploratory Brady violation, Your Honor, to discover Brady evidence and to reveal the whole personnel file. She's correct when she says that the state has turned over a memorandum of disclosure and also the attendant documents to that memorandum of disclosure for the violation of Daniel Zimmerman in this case. And the state timely turned that over, I believe in early April. And that's been made available for the past 3 months, 2 months.
Your Honor, can I get clarification on what the witness is talking about? I did not have any information about this information. The Brady's been turned over with Officer Zimmerman. All I have online is a memo of disclosure.
May I respond, Your Honor?
Yes, sir.
Okay. I am opening up the discovery log for this case. Okay. Yes, the suspension paperwork has been made available to the defense since April 9th of 2020, in addition to the memorandum of disclosure for this officer, which was made available that same day. And so I don't know if the defense counsel just missed that, but it's been part of the record, the discovery, the same day that the memorandum of disclosure has been made, Your Honor.
And Your Honor, I do apologize. I stand corrected. I do have the suspension paperwork, but also what I'm talking about is the additional conviction records that the state requested of the defense counsel. So yes, that would entail the full record of this officer. So if I may respond to the state's argument.
Go right ahead, I'm listening.
Yes, Your Honor. The state specifically said that suspension is not enough to trigger this Brady request. And the state is true that that is not enough. However, this is automatically by law, not just the constitutional Brady versus Maryland, but it's actually codified in 39.14 that the state is always under an obligation to be able to disclose information that can be used, what we call Brady, but that can be used as impeachment, mitigating, or just any evidence in trial. And for those reasons, we are asking, and like I said, coupled with the fact that the state put in a request that the defense disclose this information, it leads me to believe that there may be something out there that I am missing. And if that is true, I need to be able to get this information. And if we need to, if the state has concerns about confidentiality or anything like that, we can always do an in-camera inspection once they provide and disclose this information. But right now, given everything that I've been presented with, I feel like I am entitled to this information, and it can and may be used in my client's defense at trial.
All right, if on the issue of Officer Zimmerman, if you have material other than what you presented, Mr. Yanta, then I direct you to present it, or in the alternative, request the court's review in camera on the specific issue or issues. It's intriguing to me that the state has asked for some discovery under Rule 69, what are the parameters of that, of the response as far as timelines or anything else? If you don't do it in the form of a motion, or at least requesting an order from the court, you know, it's up in the air. So I would caution both of you to be careful with that.
And Your Honor, the state recognizes its Brady duties and its duties under the Michael Morton Act, and at all times complies with that. And so the obligation is ongoing, and the state's
Right.
aware of that, Your Honor. I just want it known.
It's an affirmative requirement that it's ongoing.
And Your Honor, just for clarification, when you're saying if the state has, the San Antonio Police Department is an agency of the state, so that puts it on the district attorney's office that this is to be considered in their possession. And if there is something out there, they have the obligation to be able to share it with defense counsel.
Right. And also, I would suggest to you, in a ounce of prevention being, what is that, worth a pound of cure, you can also subpoena those records, Ms. Gonzalez, if you have suspicion or concern. And
Correct, Your Honor.
in return, what will happen is the city of San Antonio will invoke its authority or its right to protect its files and require an order from me, which I have given in the past. And we have done the in-camera reviews with the resultant order one way or the other, and including some redaction. So, you know, that is something that you may be entitled to, or what steps you take. I'm not going to direct you on how to defend.
Thank you, Your
Mr.
Honor.
Yanta, I think you both are on the ballpark. You know what you're doing and which way you're heading. And I respect that.
Thank you, Your Honor.
Anything else, Ms. Gonzalez?
Yes, sorry. One last thing that the court reporter reminded me of before we started the hearing is that I need to state for the record that I have submitted evidence on behalf of my client for the purposes of this hearing, but everything was done electronically. I will maintain those that evidence, and at a later date, I will tender that to the court reporter to actually put in her file, so it may be properly preserved if it is going to come up later on appeal.
Very good. All right. Then anything else, Ms. Gonzalez?
I have nothing further. I would just ask that I be excused momentarily to be able to speak to my client to be able to explain this, and then I can be excused from the entire meeting. I have nothing further for the court.
Thank you, ma'am. Mr. Yanta, anything?
Judge, this is Michelle.
Michelle?
Oh, okay. I was just wondering on those motions that you granted, I can send them to you, and then if you give me the order so I can put them in the file.
Yes, ma'am. Yes, you can, and yes, you must.
Okay, thank you.
Thank you, dear. Mr. Yanta?
Your Honor, did you? It was my understanding that you didn't grant the motions as filed, but actually modified the order that was put on the motion for discovery. The state recognizes, of course, its continuing obligation to turn over Brady information, and will continue to do so. But was it Your Honor's? I just want some clarification on Your Honor's ruling on this motion as far as an in-camera review, because the way I understood it, and forgive me if I'm wrong, was that if the defense counsel wishes to do so, she may subpoena those records. But as for the actual order attached to the motion, that's been modified by Your Honor's ruling today, has it not?
I couldn't tell you for sure. I will suggest this at this point, that you are aware of some item or items involving Mr. Zimmerman. I would suggest to the state, since you are now on notice that there is or may be a significant question under Brady, it might behoove you, because you have an affirmative responsibility, not just to be aware, but an affirmative requirement to seek Brady information material. You may visit with the city and perhaps even discuss or review his files to the extent that you can. At the same time, Ms. Gonzalez will have the right to subpoena his file, and the city will respond, as they do, and understandably, that they would want me to do an in-camera review. So it's kind of a two-way street here. You've got your affirmative requirement or duty, and Ms. Gonzalez, acting appropriately, may choose to do what you both may wind up doing together, but are individually. So as far as that's concerned, I don't know what the order is. I don't have it in front of me. I will review it when it's sent to me by Ms. Garcia, Michelle Garcia. And if I have to make changes, I'll direct them through her, and I'll try to sign those papers. I'm having a wonderful time signing those things.
And Your Honor, thank you. And that the direction of the court does make sense to me. I did forget one thing. I will draft as soon as I can. I will draft that motion for an appointment of an investigator, given these two new issues. And I will approach the court remotely with that through e-filing for those, the appointment of
That's
the
right. No problem.
Okay.
Okay, then this, believe, hello,
I just emailed them to you.
already. Nothing like efficiency, huh? Thank you, Mija.
You're
Thank you, folks.
Nothing further from the state, Your Honor. May the state be excused.
Yes, you may. Thank you for your
Thank
time.
you.
And Your Honor, if I think Patty's the host, if she can put Christopher and I in a breakout room real quick, and then we'll be done.
Miss Patty, are you all right? Hello?
She may be brushing her
Yeah.
hair.
Yes, sir. I'm here. I'm here.
All
So
right.
I was told to mute.
Yes.
Okay. You're in control, Patty?
Yes, sir. I got it. Everybody needs to exit except for Jessica and Mr. Sanchez.
Alrighty.
Thank y'all. Y'all have a great one.
You
Thank
too.
you, Virgil.
All right. See ya.